Hi to everyone joining us today. We're just going to get the conference started in a few minutes, so bear with us until 1 o'clock Vancouver time. Thank you. Hi, everyone who's joining us online. We're getting started with the conference in about 1 minute, so just hang on and we'll get started shortly. Thank you. IHL Conference. It's 1 o'clock Vancouver time, so I think we'll get started. So welcome to the Vancouver IHL Conference in Cyber Warfare. This conference is presented by the Canadian Red Cross. My name is Karen Stone. I'm the IHL coordinator for Western Canada and part of the IHL team here at the Canadian Red Cross. Before we get started, I would like to begin by acknowledging that the land on which I sit is the traditional territories of the Anishinaabe, Cree, Dakota, Dene, Métis, Oji-Cree nations, and on Treaty 1 territory. And the land on which our event was originally scheduled to take place in Vancouver is the traditional unceded Indigenous territories of the Musqueam, Squamish, and Tsleil-Waututh First Nations. I know from the registration list that we have a diverse group of academics, humanitarians, students, and other professionals joining us from across Canada and beyond. So thank you so much on behalf of the Canadian Red Cross for your participation today. Before I pass the floor over to today's speakers, I would like to draw your attention to the Q&A box located in the bottom menu bar of your screen. You can ask questions at any time during the webinar. However, we will hold questions until the designated Q&A times throughout the conference. Now, if you're joining today on YouTube, you'll be able to submit your questions online by following the instructions displayed on your screen right now. So you should see questions to go to Slido and enter the event code, and you'll be able to ask questions. So that's if you're watching on YouTube today. You'll also notice a chat function. If you experience any technical issues or would like to share any other comments, you can share in the chat and we will try and solve your problem as soon as we can. Now, I recognize that most of us have experienced a shift in our personal and professional lives over the last few weeks, so your participation is extremely appreciated and welcome today. Today's conference is on the topic of cyber warfare, and our speakers and panelists will be looking at the role of cyber capabilities during armed conflict and looking at what protections are in place to protect humanity from the effects of cyber operations, as well as exploring contemporary challenges in today's increasingly connected cyberspace. Now, today's conference will begin with an introduction to international humanitarian law by Catherine Gribben from the Canadian Red Cross. Then we will have our keynote presentation by Professor Eric Talbot Jensen from Brigham Young University, followed by a panel with three esteemed speakers, Professor Paul Meyer from Simon Fraser University, Ijeamaka Anika, who is a PhD student at the University of British Columbia, and Dr. Ahmed Alrawi, professor at Simon Fraser University. Also, you'll notice on the call as well is my colleagues, Samantha, who will be moderating today's discussion and Q&A a little bit later, as well as my colleague Arena, who is a legal and policy officer with the Red Cross movement, who is also here to support today's conference. So thank you so much to the speakers and panelists. Now I'm going to pass the floor over to Catherine, our first speaker. Now, Catherine Gribben is the Senior Legal Advisor for International Humanitarian Law at the Canadian Red Cross. Catherine has worked at the Canadian Red Cross in a number of different positions since 2006, including serving as Operational Legal Coordinator for the ICRC's Nigeria delegation. So Catherine, over to you.
Okay, hello and welcome everybody. So you're just going to bear with me for one awkward moment whilst I share my screen with you. It is such a pleasure and delight to have everybody on the call, and we're delighted to be taking this online with you. So I'm just going to start my slideshow and do this, and there we go. I think we are ready to go. So I have the pleasure of giving you an introduction to IHL. So I'm going to be taking about 25 minutes or so, followed by questions, which I'm really looking forward to. And throughout the presentation, you're going to be seeing a couple of survey questions to get a sense from everybody who's joined, their understanding and what some of your expectations are related to international humanitarian law. So today, in the introduction, when does IHL apply? The rules related to the fighting itself, we refer to that as conduct of hostilities. We're going to be talking about protection, so what Karen had mentioned in her introduction, the individuals who are protected during times of armed conflict. And very briefly, we're also going to be talking about the issue of compliance. Now, in my general introduction, you're going to be thinking probably a lot about the kinetic operation. So in very simple terms, we're talking about the idea of dropping a bomb on a tank. And what Eric is going to be doing in the second presentation is taking all of these rules and bringing them down and applying them to the realm of cyber. And so I'm really, really looking forward to his presentation and all the nuances and scenarios that we're going to be able to dive deeper into and realize some of the difficulties that is being faced by those who are dealing with cyber operations and cyber operations as it relates to times of armed conflict. So what is IHL? What is international humanitarian law? International humanitarian law can also be referred to as the laws of armed conflict. In some places, it's also referred to in the laws as the laws of war. But for the sake of this presentation today, I'll be using the laws of armed conflict and international humanitarian law interchangeably. So international humanitarian law is the body of law that governs the use of force, the fighting that takes place during times of armed conflict. It lays out limitations on fighters and combatants as to what they are permitted and not permitted to do. It also outlines the protections that are afforded to civilians, those who are no longer engaged in the fighting, and the protections that need to be given even during times of armed conflict. Now, IHL applies to everybody who's engaged in the fighting, so that can include a non-state armed group. It can also include, obviously, governments and armed forces. And so when we're talking about IHL, we're talking about the rules that apply during times of armed conflict. It applies to the fighting that is taking place, and it speaks to the parties, and it says, here's the limitations on what you can and cannot do, and here are the protections that you have to give to those who are civilians, those who are being detained, those who are no longer able to participate in the fighting. So international humanitarian law, and our speakers later this afternoon, Paul, Emeka, and Ahmed, I really like you to think about the different bodies of law that are going to apply to all of the different scenarios that they're speaking about. And so realizing that IHL is one body of law that intersects and interplays and impacts the realities that you're going to be hearing about later on this afternoon. So our first survey question. So if, and you're going to see it pop up on your screen, I encourage everybody who's able to answer it. And so if a war is illegal under the UN Charter, illegal or not permitted under the UN Charter, do fighters have to follow the rules of armed conflict during the fighting? So I encourage everybody to take a stab at the answer. We'll give you about 10-15 seconds to fill in the survey, and then the answer will pop up on everybody's screen. Again, so if a war is illegal or not permitted under the UN Charter, do the fighters have to follow the rules of armed conflict, so IHL, during the fighting? Excellent, that's great to see. So yes, that is the correct answer. The fighters do have to follow the rules of armed conflict during the fighting, even if it is deemed to be not permitted or illegal under the UN Charter. So we'll just take 1 second. There we go. So, and why is this the case? So under the UN Charter, governments agreed in the first instance that war would actually be prohibited as a means by which to reconcile differences between states. And there's only 2 exceptions, so that of self-defense or with authorization, right, from the Security Council. And so we know, you guys have all heard this in the news, when we say, oh, it's under Chapter 7 or it's a Chapter 7 authorization, that's what international law says to states that they have to do in order to be able to use that force. But international humanitarian law says that regardless of the legality of the use of force in the first instance, that international humanitarian law nevertheless applies to that scenario. And why is that the case? Well, the protection for those who need protecting during times of armed conflict continues to exist, right? So we still need to make sure that civilians are protected, those who are detained are protected. And we have to make sure that even during times of armed conflict that are not permitted under the UN Charter, that there are still limitations given to the fighters. So there are still limitations given to the soldiers saying, yes, even though under this body of law, that use of force may be illegal, international humanitarian law still has to be applied, and realizing that it's even during times of armed conflict that we have to make sure that that protection and that limitation continues to exist. So thanks so much. Great to see everybody participating in the slide there. That's wonderful. So the next question. Is there a difference between international humanitarian law and international human rights law? So for those who maybe didn't participate in the first one, maybe you can participate in this one as well. So is there a difference between international humanitarian law and international human rights law? Ooh, and we have survey results. Yeah, there we go. That's a great answer to see there. So yes, there is definitely a difference between international humanitarian law and international human rights law. And so what is that difference? International humanitarian law, as I had said in the introduction, it applies during times of armed conflict. So it is a specific body of law that speaks to the fighters, it speaks to the parties to the conflict, and it says, this is how you must interact and engage during times of armed conflict. International human rights law and human rights law, domestic human rights law, is a different body of law. It applies in its totality during times of peace. So even if a situation can look quite violent, you look, for example, at the scale and escalation of violence during the Arab Spring, you had some countries that stayed, even though it could look quite tumultuous and there can be quite a high level of violence. There are some countries that never actually, it never actually crossed the threshold into a time of armed conflict. And what was taking place during those particular times was governed by human rights law. But what's very important, and again, I want you to think about this interaction and interplay between these two bodies of law when we're hearing our speakers later on this afternoon, is that there are some fundamentals that continue to exist and overlap between the two. So even during times of armed conflict, we have an absolute prohibition, for example, on the use of torture. We have an absolute prohibition on the use of cruel, inhumane, and degrading treatment. So for those who are studying this area of the law, this interaction between human rights law and humanitarian law, you know what the joke is, if you put 7 lawyers in a room, you'll end up with 10 opinions. I would say on this body of law, if you put 10 lawyers in a room, you may end up with 27 opinions on the interaction and interplay and the dynamics between the two of them. But what's very important is that when we're talking about protection of individuals who need protection, even during times of armed conflict, there are some fundamentals that continue to apply, and we have to be cognizant and mindful of that interaction and interplay between the two. And realizing that when we are turning into and when we're looking at a situation of armed conflict, we're going to be looking at international humanitarian law for the rules that define how parties to the conflict are going to be fighting and the protections that need to be afforded to those groups who need protection, even during times of armed conflict. So you guys have heard me say several times already in times of armed conflict. So how do we know when that happens? From a legal perspective, we have a couple of authorities that we want to turn to in order to make that distinction. My team always makes fun of me, but I never have the Geneva Conventions far away. So one of the first places we turn to is we actually look to the Geneva Conventions. And you'll see this quote there on the bottom of your screen, the citation there. And it says, "The present convention shall apply to all cases of declared war or any other armed conflict which may arise between 2 or more high contracting parties," so parties who have signed on to the conventions, and all governments have signed on to the Geneva Conventions, even if the state of war is not recognized by one of them. In addition to the treaty law, so this is an example of one of our treaties within IHL, we also turn to case law. So for those who have worked at the ICTY or who have studied international law, we know we have, the ICTY is the tribunal for the former Yugoslavia that was dealing with violations that took place during that armed conflict. We have a couple of leading cases that we turn to in order to be able to find out, well, what exactly is this classification? What is an armed conflict? And we can turn to the Tadic case, or one of the Tadic decisions, to see that, and this quote is there up on the screen for you. So it's a resort to armed violence between states. So that's that example in the Geneva Conventions, that example of the interaction between the high contracting parties. We can have protracted armed violence between a state as well as an organized armed group. So that's the state and the organized armed group. Or we can have protracted armed violence between those non-state armed groups. So it's possible to have an armed conflict without a government even actually being a party to the conflict. So when we're talking about and we're making this determination when we're already be able to say, so this is a situation of armed conflict, and therefore IHL applies. So in order to make this determination, you really have to look at the facts on the ground. What do the facts say? We can have situations like I had mentioned earlier, for example, during the Arab Spring, in which case we had sporadic and there was violence in different places around varying countries. You had an escalation in the use of force between the various civilian groups that eventually moved on and became non-state armed groups, as well as that level of violence between the state itself. But if it doesn't meet that threshold, it stays below that threshold of an armed conflict, then we're going to be really looking at, what does the domestic law say? What does it say about how the police can be used? What type of force that they can use? Whether or not the armed forces should and can be involved in that particular response? What is the type of force that's being used by those who are participating in the disturbances? But if it remains below that threshold, then we're going to be turning to domestic law in order to make that determination. But if we arrive in a situation of armed conflict, we're going to arrive in one of two places. So we're going to arrive either in an international armed conflict or a non-international armed conflict. So let's say the example I had just used, we have a situation that's within a single country. We have fighting between a government force and a group of individuals who start to form. If those groups of individuals start to form and they become sufficiently organized and there's a sufficient degree of violence, then that situation can become a non-international armed conflict. So that's between the state and a non-state armed group with a sufficient level of violence and a sufficient organization, and that is a situation of armed conflict. The other example, again, using our Geneva Conventions to say, or TADIC saying it's a use of force between at least these two states. Now, Eric in his presentation is going to be pulling us into the world of cyber. What does it look like for there to be armed force between two states in the world of cyber? And Eric is going to be really blowing our minds in order to be able to raise some really difficult questions about how governments and states are determining how they can respond to these allegations and these instances that are taking place around the world. So international humanitarian law is this finding of this right balance, because we find ourselves now in this situation of armed conflict, and we have to do this balancing act between military necessity on one hand and that of humanitarian consequences on the other. And unlike in international human rights law, you don't have to do that balancing between that military necessity and that of humanity. But now we're in a situation of armed conflict, and we have to do this balancing act. It's a really profound balancing act that really manifests itself when we're talking about protection, as well as more specifically related to conduct of hostilities. Now, under IHL, I had said we kind of look at it in two strands. So one is looking at the protection of persons. The other is how our soldiers or fighters, how are they permitted to fight? And that's related to, and how we phrase that is the rules around the conduct of hostilities. So under the conduct of hostilities, I'm going to focus on three particular principles. So the principle of distinction, the principle of proportionality, and the principle of precautions. So what do each of these principles say? The first principle is that of distinction, and it says to the fighters, it says to the soldiers, you can only launch your attack against that which is a lawful target. So those who are fighting, so combatants or civilians who are directly participating in hostilities, as well as military objectives. So that which is contributing in the nature, purpose, location, or use, it's contributing towards the military function. In addition, it also says you have to distinguish between those who are specially protected persons. So you'll see at the bottom of the slide, those, for example, who are wearing the Red Cross, Red Crescent, or Red Crystal. They're protected and they cannot be targeted under IHL. So again, we have our first rule to our fighters, our soldiers, saying you can launch your attacks and direct your fighting towards that which is a lawful military target. Secondly, when you launch your attack against your lawful military target, you have to be governed by the principle of proportionality. And that says that this anticipated incidental civilian damage, so the civilian damage that is anticipated, it has to be balanced and it cannot be excessive to the concrete and direct military advantage that is gained. Now, in common parlance, that oftentimes people refer to that as collateral damage. So this means that the idea that there actually can be loss of civilian life, damage to civilian infrastructure, that's not excessive to the concrete and direct military advantage. And therefore, that actual loss could be proportionate under international humanitarian law. It's this extraordinary reality that happens under this body of law. And finally, the principle that I'd like to bring your attention to, in which Eric is going to unpack even more for us within the world of cyber, is all the steps that a fighter has to take in order to ensure and verify that the objectives, for example, are indeed military objectives, that there's an evaluation of the attack and obligations related to canceling of an attack if those steps aren't able to be made. So our next survey question, is it legal to target a wounded combatant who is no longer fighting? So let's take about 10 seconds here, and we'll see what people think. Is it legal to target a wounded combatant who is no longer fighting? So I encourage everybody to fill that in. Great to see as many people as possible. Oh, yes, that is absolutely correct. It is not legal to target a wounded combatant who is no longer fighting. And why is that? That's twofold. One, we know from our distinction rule that those who are not participating in the hostilities, those who are hors de combat, they are no longer lawful targets under IHL. And if we look to the early drafting of the Geneva Conventions, the first treaty, and I'm going to again hold this up because this is my geeky, excited, it says under the Geneva Conventions, our first convention is related to the condition of the wounded and sick in armed conflict. So they were the first group under IHL to be recognized that they needed protection during times of armed conflict. And so we know that those who are wounded, even if they're on the other side and even if they're receiving medical assistance, those wounded combatants, they're no longer able to participate in the fighting, that they are in fact protected under IHL. And that means that they cannot be targeted, and it can also mean that they actually are entitled to specific protection, including the provision of medical assistance. So when we're talking about protection, we want to also remind ourselves that that there's individuals who need protection during times of armed conflict. So this, of course, includes the civilian population, including the civilian population of the other side who you may be fighting against. It's not lawful to target them, but it's also not lawful to, for example, use starvation as a tactic against them. It is not lawful to prevent humanitarian assistance from receiving them, being able to arrive to them. You also have to make sure that as a fighter, as a party to the conflict, that those civilian populations, even the civilian population of an occupied area, that those civilians must be able to maintain as much normalcy really as is possible. So in addition, we have specific groups who are, for example, could be more vulnerable, in particular children, for example. So we have specific rules that relate to the prohibition on the recruitment of children during times of armed conflict. And as I had mentioned earlier, we have that even those who are detained, who were fighting for the other side, those individuals still need to be protected. They are guaranteed humane treatment, and there is the absolute prohibition on the use of torture, the use of cruel, inhumane, or degrading treatment. So we now know that we have those expectations around what the rules are, what the expectations are on the limitations. So IHL really says that even during times of war, even wars have limits. And it also speaks to the parties of the conflict and says that even when you're fighting, there are particular people and particular groups of people who need to be guaranteed that protection even during times of armed conflict. So what happens and how do we make sure that soldiers and fighters comply with IHL? So a question for all of you. Is the International Criminal Court the only court responsible for dealing with violations of IHL? And I'd ask for everybody to take a shot at answering this one. We'll give you a couple of seconds to take a shot. Hopefully everybody's still awake. Ooh, we have the results. Absolutely. So that is correct. So the majority is correct. Oh, no, I take that back. So is it the only court responsible? No. Okay, great. Sorry, I got confused by my own question. So the International Criminal Court is not the only court responsible for dealing with violations of IHL. Again, the first place that I'm going to turn to is looking at the Geneva Conventions. And there's what is called the grave breaches regime within the Geneva Conventions. And we can find that applying to international armed conflict, finding the provisions throughout the 4 Geneva Conventions, as well as additional Protocol 1 for those who have signed on to it. And there's expectations that there must be efforts made in order to repress and suppress violations of IHL. So making sure it's what is referred to in the conventions as effective penal sanctions in order to deal with violations of IHL. So when a government signs on to the Geneva Conventions, they commit to ensuring that there are effective penal sanctions to prevent or attempt to prevent violations of IHL taking place. So on top of those international treaty obligations, you also have other international law as well as national criminal law, all that can deal with violations of IHL. And not just criminal law in the civilian sense, but also within military justice. So in Canada, we have a very robust military justice system, all that lays out what the expectations are on soldiers, and if they violate rules under IHL, what the consequences are for them. This is the case for many governments around the world. All the efforts that are made in order to ensure that their soldiers and their fighters are going to follow the rules, and that if they don't follow the rules, what the consequences are. So in addition to the military justice system, we also have the civilian justice system. And we have that within criminal law. For example, we had a couple of cases here in Canada that dealt with allegations of violations of IHL in Rwanda during the Rwandan genocide. There's also instances of that other countries around the world dealing with allegations of violations of IHL. And then we also have the International Criminal Court. So that was created to deal with the most responsible. And so if a country is unwilling or unable to deal with the violations that take place, so the grave violations, so looking at war crimes, crimes against humanity, the crime of genocide, if the country is not able to deal with that within their domestic system, that then they can refer, or the case can be referred in multiple different ways to the International Criminal Court, or the ICC. But criminal law really only kicks in, it can act as a deterrence, but it only kicks in after the violation has taken place. And there's a lot of work that's done in order to attempt to increase compliance in the first place. So how do we do that? we work to make sure that soldiers are aware of what the rules are and that they understand what the consequences are for not following the rules. So for example, in Canada, Canadian soldiers receive extensive instruction on IHL, including carrying in their pocket what the basic rules of IHL are, and they're trained and understand what the consequences are. There's other international mechanisms that attempt to look into, research, regulate, make findings and statements about what's taking place in various countries. The UN can set up systems in which they're investigating particular countries, and you can find that all around the world, investigation into allegations. In addition, for example, you'll also find reparations back to the actual victims of the violations of armed conflict. And that is done by a couple, governed by the Rome Statute. You also have civil society around the world in domestic context who are advocating for civilians who have been the victims or who have suffered the consequences of armed conflict and who are advocating for reparations. And then there's all of us as informed, engaged citizens who learn about IHL and who work with our governments, who advocate with our governments, engage in discussions with those who are responsible to make sure that others do follow IHL and that we're learning about what their obligations are, that we then also work with our governments to ensure that there is accountability across the board. So I am going to wrap up here. I'm going to hand the floor back to Karen. So I'm going to stop sharing of my screen, and we're going to invite Eric to join us for the Q&A. And I really look forward to the discussion. Thanks so much for everybody's time.
Thank you so much, Catherine, for that fantastic introduction to international humanitarian law. We have a few questions that have appeared in the Q&A and through Slido. I just want to let everyone know that there's still time to get your questions in through the Q&A, or if you're watching on YouTube, if you go to Slido and enter the event code IHLVAN, that's IHLVAN, and then you're able to ask your questions there as well. So let's get started with the Q&A. The first question we have is, why is it called international humanitarian law?
Oh, I see Eric's muted himself. He's like, over to you. So yeah, I can see that. I can see that's there. When we talk within the world of the Red Cross, for example, it is really to highlight the fact that we are attempting to bring humanitarian considerations even during times of armed conflict. A lot of times I hear the phrase, well, it's war, it's all chaos, all bets are off. And humanitarian law reminds us, and it reminds those who are responsible for the fighting and what takes place during times of armed conflict, that actually not all bets are off, that there are rules, there are humanitarian considerations and consequences. And we have to make sure that that's one of the key considerations that come into play when we're making these difficult decisions. Those who are fighting, obviously, are making life and death decisions, sometimes on a daily and hourly basis. And so it's reminding us as a collective that humanitarian law reminds us of those humanitarian considerations. Eric, did you want to weigh in on that?
I would just say that sometimes people they create kind of a bifurcated system where there are humanitarians and soldiers, and that's clearly not the case. I mean, everybody engaged in armed conflict should be a humanitarian, have these humanitarian ideals that Catherine explained so clearly in mind when they engage in armed conflict.
Thank you both. Our next question asks, how would IHL apply to what was happening in Hong Kong, and then also taking a note China and the law's government in regards to their unique situation of a one country, two systems?
Sorry, could you ask, I feel like I lost you a little bit there. Would you mind repeating that, Karen?
Oh, sorry about that. So the question was wondering if how would the law of IHL apply to the situation in Hong Kong? I'm assuming they're referring to the protests, and then also taking note of the unique situation of the one country, two legal systems between China and Hong Kong.
Oh, okay, gotcha. Okay, Eric, did you want to take a first crack at that?
Sure, I can. This again is my own view, but as Catherine explained, there is an international armed conflict and a non-international armed conflict, and then there is just the question of whether or not you're in an armed conflict. And I think that that's really the question we would have to face in the Hong Kong situation: is have we risen to the level of armed conflict? And unlike an international armed conflict, where any kind of conflict between two governments, like the US and Canada, any conflict between those two governments, all of the rules of IHL would apply. In a non-international armed conflict, as Catherine explained, there is a scope and intensity requirement. You have to get it's not everything that transitions you to applying the rules of armed conflict. Normal riots, normal disagreement with the government, those things don't rise to the level of armed conflict, and therefore the armed conflict rules would not apply to that situation. And as I understand that situation, as I looked at it from my view, it didn't seem like there was an armed conflict in that situation that rose to the level of a time when we would apply those rules. Catherine?
That's great, Eric. Thanks so much. Yeah, I agree. We have to make sure that when we are making that determination, we turn to what the law asks us to make that determination based on, and we always have to look at the facts. So the case law, for example, coming out of the ICTY, there's one case that I cited, but there's a number of other cases that we can turn to. And you have to look at, so when I talked about the organization of the group, so you actually have to look at the command structure. Are they able to exercise and operate? Are they able to execute commands? Are they able to ensure discipline? That's one element of it. Excuse me, but the other element of it is that there also has to be the sufficient level of violence. So it has to look at the type of weaponry that's used, the extension or the time period of the violence, the violence between the groups themselves, the number of victims, so the level of destruction. And as Eric said, when we make that determination, we have to look at, it can actually look shy of an armed conflict, can still look very violent. It can look very chaotic. It can look almost like it is a situation of armed conflict. But if it is below that threshold, then we want to make sure that actually IHL doesn't apply. And we have the human rights regime, which allows for a more gradated use of force in that particular situation before we would actually make that determination that IHL applied. So hopefully that answers that question.
Thank you both. We had a question that came through the chat, and I see that Eric has provided an answer in the chat, but I'm not sure if everyone saw it. So I'm just going to read the question, and then maybe I'll flip it to Eric first to answer. So Bridget asks, is there a distinction in IHL that determines whether economic sanctions are illegal if they cause things like food shortages? Eric, do you just want to summarize your response that you typed out?
Sure. So economic sanctions, like the one that many of the U.S. and some of the countries in Europe are putting on various countries like Iran or North Korea with respect to programs, those are not IHL type sanctions. Those are sanctions that come under the UN Charter and are either directed or allowed by the Security Council or just by nations working on their own. And those, I think, are not the ones that you're concerned about in this question. It sounds to me like the question you're getting at is what we would call humanitarian assistance, which is in a time of armed conflict. Let's say that, I mean, armed conflict is a horrible thing, and there are oftentimes people who are living in zones of armed conflict who have great needs, who aren't getting food and water and the other things they need. And I think what your question is getting at is, what are the rules about that? And in general, the rule is that the parties who are engaged in armed conflict cannot arbitrarily deny humanitarian assistance. And now we can have a long discussion about what it means to be arbitrary and what states can do. I mean, there is a right to inspect. There are lots of smaller rules that underlie that, but the general principle is that state that parties to a conflict cannot arbitrarily deny humanitarian assistance.
Thank you, Eric. Catherine, do you want to?
Yeah, I'd love to. Eric, thanks so much for that. Because when we're talking about what IHL says, it says that your civilian population have to be protected from the effects of the hostilities. And so that means they have to be able to receive that humanitarian assistance, receive and be entitled to the means necessary to their survival. And so when we're talking about the parties to the conflict, there's, as Eric had said, there's the ability, of course, for them to be able to inspect, because again, this is a balancing. It's a perfect example of balancing of that military necessity against the humanitarian considerations and consequences. But just coming back to something simply that I said earlier, that there's that prohibition on the parties to the conflict to use starvation as a tactic during times of armed conflict. And so this is working towards the fact that you cannot deny that humanitarian assistance to that civilian population, as Eric had said, on an arbitrary basis.
Thank you. We have several more questions, and we only have 3 more minutes left for the Q&A. So I just want to let everyone know that if we don't get to your question, we'll try and get to them a little bit later. There'll be more opportunity, but let's try and get a couple more. Christina asks, some states aren't recognized as independent sovereign states by some members of the international community. So if there's an armed conflict between one of these territories and another state, would this be a non-international armed conflict or international armed conflict? And then a follow-up question, could or would humanitarian forces, I guess peacekeepers, be sent in this case? Who wants to start?
I'll take a first crack at it. I feel like this is a massive question, so I'm going to kind of answer it in brief, but realizing that you could really unpack it. We could spend a week talking about it. I would say it depends. I know that's a frustrating answer. It really depends on the situations and the individual contexts. So first of all, you would look at that. And whether or not it is an international or non-international armed conflict. One of the things that we do within the Red Cross, for example, is it's not always necessary to make those declarations public. And we can make those declarations or we can make those analysis and then engage in discussions with the parties to the conflict that regardless of whether it's an international or non-international armed conflict, there are still limitations to how they can engage in the fighting and the protections that are afforded. And can the UN deploy troops under a peacekeeping mission or otherwise? Yes, they would be able to. Again, it would depend on the specifics and the authority that is given. Eric, is there anything you want to add to that? Far too short an answer.
Let me just add one thing quickly that underscores what Catherine just said. There's a provision in Article 4 of the Prisoner of War Convention that says that people who are members of organized armed groups can't be denied prisoner of war status simply because one belligerent says we don't recognize you as a country. And I think that principle underlies all of the law of war, in that we're trying to get protections to as many people as we can, and you can't have a political decision that removes those legal protections.
Thank you. Okay, I'm just going to ask one more question, and then I'm sorry if we didn't get to your question, but we'll try and get to these questions in the next Q&A. We had a couple of people ask about the case of Omar Khadr and what role, if any, IHL played in this case.
So yes, it absolutely played a role in this case. So there were allegations of him being alleged to have violated the rules of armed conflict. So and within the particular case itself, when you look at the Canadian Supreme Court decisions, they also made reference to the allegations within IHL. It's also really important for us to remember when I had mentioned earlier about the protections of children under IHL, Omar Khadr, during the time of those allegations, was in fact very young and would have been protected under IHL from recruitment, and then obligations that are entitled to him as a former combatant as a child. So again, we could spend a huge amount of time talking about that case. I had the privilege actually of attending an amazing talk that Mr. Cotter and Ishmael Bea recently gave in Halifax, and spoke about their experiences as former child soldiers. There's layers and layers to that case that really, as a case study, as it relates to IHL, the recruitment of children, the accountability or justice that people are subject to afterwards. We could spend a lot of time on that, and for those who are interested in learning more, I really encourage you to do so.
Thank you so much. Eric, do you want to add anything? I'm not sure if you're familiar with the case. No? Okay. Okay, so I'm going to wrap up this Q&A session. Again, please, we'll try and get to your questions. And thank you so much for all the insightful and interesting questions that you've made so far. I'm really pleased with the discussion thus far. So now I'm going to actually pass the floor over to Eric. And now Eric Talbot Jensen is a professor from Brigham Young University Law School in Utah. He teaches and writes in the areas of public international law, criminal law, the law of armed conflict, international criminal law, cyber law, and national security law. He is a leading expert on cyber warfare, including serving as a member of the group of experts that produced the Talon Manual on the international law applicable to cyber warfare, as well as the recently released updated manual on the same topic. So thank you so much, Eric, for being here today, and I will pass the floor over to you.
Okay, great, thank you. I am going to share my screen. All right, so I hope you can all see that first slide. Okay, good. So this is who I am and this is what I'm going to talk about, and let's get started. So why is this even a topic? Why do we even talk about cyber warfare? I mean, you know, we talk about applying the law to tank warfare when tanks were developed. We talked about applying the law of war to air warfare when air warfare was developed, because these things changed. And so that's why I think it's important to talk about applying the law to cyber warfare. And I just want to take a minute and thank Karen, Catherine, and Samantha, and everyone else at the Canadian Red Cross for doing this conference. I think it's really important to note that as we develop cyber warfare, we need to talk about it, talk about the rules, the regime that applies, and think about how it might stress some of the current rules of armed conflict and how we might apply that as these things develop. I also want to thank Catherine. She set me up absolutely beautifully for this. I feel like I hardly need to talk. I should really just probably answer your questions because your questions are so great. But let's talk about cyber warfare a little bit. Why is cyber warfare different than tank warfare or air warfare? Why is it such a topic? And let me give you a couple of reasons. Number one is the ubiquity of cyber things in our world. Cyber is everything. You've all probably heard the term Internet of Things, and that's what connects your refrigerator and your washing machine to the internet. It is ubiquitous in all that we do. In fact, here is a chart from this is 2019 year-end estimates, but look at those numbers. 7.7 billion people and 4.5 billion internet users. So the 58.7% penetration rate of the internet is a real indication as to why cyber things are important and why we need to have this discussion. So in addition to the ubiquity of cyber things, there's also this issue of an increased target set. When you think about what you can reach with a normal bomb or a machine gun or a bullet in armed conflict, and then think about the things that are connected to the internet and what you can reach with the internet or what can be reached through the internet, it's a really daunting thought about the expansion of the target set that might show up in armed conflict. And if military planners are thinking about all the targets they can reach with cyber tools, it's an immensely expanded set of targets. And so we need to think about how the law might apply to those planners and how they think about this. And the third reason is that these cyber capabilities broadly disseminate state level violence. When you think about things like kinetic weapons, tanks and airplanes. I mean, you know, your neighbors don't have a tank parked in their driveway. These things are really contained at the state level, and it's really only states that have that kind of military hardware. But cyber tools are not the same. The broad dissemination, the ubiquity of cyber tools means that cyber stuff is going on all the time, and it reaches far more, such a great, more expanse of our world than just what we normally would see. And that then people, individuals, groups, transnational criminal organizations, terrorist organizations can all control what normally would be a state level of violence. Now, let me just give you an example of that. I'm gonna stop sharing and then reshare here my screen. And I'm gonna show you a quick video that illustrates this point. So this is just a video off YouTube. And if you watch what this person is typing, he's talking about how to create a distributed denial of service attack. And this is off YouTube, and it's actually quite a tame version. Depending on where you go on the internet, you can get much more extreme and much more dangerous. I'm not suggesting this in any way. I'm just saying it's out there, that you can get much more extreme and much more dangerous examples of things you can do on the internet that really can cause serious difficulties. Let me stop sharing that and go back to my slides. All right, so we know that cyber plays this expanded role. We know it's an increased target set. We also know that cyber has already been used in conjunction with armed attacks. And I will just give you one example, and that is Russia's armed conflict with Georgia that happened in 2008. We know that in conjunction with other kinetic pieces of an armed attack or of an armed conflict, that Russian sources or Russian hackers also used cyber tools in that military operation. So, and this is not alone. I'm not trying to point Russia as the bad guy. I'm just saying this is one example where this has already happened, and it's happened in other places and will continue to happen. So this is not a hypothetical or a mythical question. This is happening now, and we need to be aware of it and start thinking about how we're going to do this and what we want to do with the rules. So the basis for this, and again, thanks to Catherine, the basis for all of our discussion has got to be the current application of IHL. I am not one of those people who believes that IHL is insufficient for new weapon systems. I actually think it's absolutely sufficient for new weapon systems, for new means and methods of warfare. We may have to adjust or evolve our understanding on the edges, but certainly with respect to cyber tools, the current law is sufficient to handle the vast majority of situations that will arise. Now, I'm going to try and point out to you in this presentation some of the areas where we might need to think a bit deeper about that, but just know that my belief is that the current law of armed conflict, current international humanitarian law, provides the answer to almost all questions raised by uses of cyber tools during armed conflict. Karen mentioned that I am part of a group that got together in Tallinn, Estonia, and produced two books about this, and I'm certainly not trying to advertise. I'm not self-serving this way, but I do believe that this compilation of information is very useful and is a starting point for people who want to read more about this. This is not the law. None of us who participated in this thought we were telling states or governments what the law was. Governments make the law, they make international law, but we thought we were trying to put our heads together and come up with our best views of how we thought the law would apply to cyber activities. And as we go through the rest of this, I will show you some excerpts from the Tallinn manual to explain maybe some cyber aspects of the application of international humanitarian law. So here are the 7 topics I want to cover in our discussion. And let's start with the principle of distinction. This is what the law says from Additional Protocol 1 about the principle of distinction. I'm sure that's very familiar to most of you, certainly based on the quality of your questions. My guess is you all know that. So how does that apply to cyber? Well, here is what those of us who worked on the Tallinn manual thought. Now, you'll see that I will put up 2 separate things under the Talon Manual. One will be rules and one will be commentary. Rules in the Talon Manual are things that every one of us experts who got together, we all agreed with. And then commentary will reflect some areas where we had questions or didn't know the answer or had different views. This was a rule. None of us doubted the fact that the principle of distinction applies to all cyber attacks. When we think about what a cyber attack might be, and I know that sometimes you read that term attack in the paper, I think sometimes it's used too broadly. Under the international humanitarian law, an attack is a very specific thing, and this is how it's defined. This again is from Additional Protocol 1. And then in the Talon Manual, we said basically the same thing. Now, I think when we talk about what is injury or death, that's pretty clear, but what is damage or destruction of objects? We had to wrestle with that. And I think as you reflect in your own mind, what is sufficient damage in a cyber world to count as an attack under the law of armed conflict? Here is what we came up with, and we disagreed on this. Those of us who met for the Talon process, we disagreed, but most of us thought that it would include interference with functionality such that you had to replace physical components on your computer. So if all you had to do is reinstall software, that probably doesn't rise to the level of an attack under the definition of IHL. But if you do have to install new physical components, that probably does. That was where we came out on this. Again, states have not clearly expressed a view, so I can't tell you precisely what this piece of the law would be. This is one of those areas where the law might be a little unclear with respect to cyber warfare, but I think it's an important question and one which we need to think about. The principle of discrimination, you see it here on the slide. Again, my guess is that you're all mostly familiar with this. The question then is, how do we apply this very clear and applicable principle to the law of armed conflict? How do we apply it to cyber activities? Well, here's what we said in the Talon Manual. And basically, we said it absolutely applies to all cyber activities, certainly all cyber attacks. Here's another statement from the Talon Manual that I think again adds clarity about what we thought. So we think just because something it uses a cyber tool, that doesn't relieve the attacker of all of the responsibilities under IHL to apply those principles as clearly and as exactly as they can. Now here is another piece from the commentary. So this is another issue about, it's basically an example. So here's a scenario. I sent Karen some poll questions. Hopefully I send them to her in time that she can put these up. There it is. Okay, so read this and tell me what you think your answer would be. Karen, you may want to put that poll down. I don't know if they can still read that slide with the pull up. Maybe they still can.
They probably have to minimize on their own screens to be able to read it. Yeah, apologies. I probably threw it up a bit too fast.
No, Karen, you're doing great. So I know that you might have more questions. You might have lots of, you may not be clear, but try and fit your legal view into one of those two options I gave you.
We're still getting some poll answers, so I'm
great. Good. This is a very thoughtful crowd. I'm interested to see what they say.
All right, I'm going to share the results.
Okay, fairly evenly split. All right, so I think that is reflective of kind of how we approach this in the talent process. It depends how you think this factors, for me at least, it depends how you think this factors into the principle of discrimination. If you can do this in such a way that it only targets the computer you're after, then maybe it's discriminating and maybe it's not. And some of you may have other reasons why you would or would not do this, but I think it's an interesting scenario, and certainly one that's capable with cyber tools that might not be capable with non-cyber tools. So let me move on to a different principle of the law of armed conflict, and that is precautions. Now, this is covered mostly in Article 57 of Additional Protocol 1, and there's a difference, of course, between Article 57 subparagraph 1, which just says constant care you must exercise constant care in all of your military operations, and then the rest of 57, which talks mostly about attacks and applies only to things that would qualify as attacks. And I've put to the side there the talent manual rules in case you want to look at those on your own. But I would just, you'll see at the bottom of my slide, I have this idea of re-engineering. If you want to go on again to YouTube, you can see cyber tools that have been used and are now out in the open and are being re-engineered by people. You can watch them on YouTube re-engineering this code. And the question, I think, for all of us is not just how do we apply cyber tools, the basics of precautions in the attack, but do we also need to consider, wow, what if that cyber tool is out there? Can someone re-engineer it? Does a commander or someone who's using that cyber tool have to consider that as part of their analysis and whether or not to use a cyber tool? I think that's a question that we need to engage on as well in more depth. Let me just highlight one of the principles of precautions in attack, and this goes back to something that Catherine talked about, and that is, what is a military objective? Because we know from the principle of distinction that all of our military operations have to be targeted only at military objects or military targets, justifiable military targets. This is the definition of military objectives, kind of a two, or some people call it a three-step process. One is that the nature, location, or purpose of the thing makes an effective contribution to the military action. And the second is that total or partial destruction of that provides a definite military advantage. I want to just walk through some examples of how you might think of military objectives and how that might be applied in the cyber realm. So something that you might think of as by its nature being a military objective is probably a tank. When I started my military career, I started out on tanks, in fact, on that tank. Though that's not a picture of me, thankfully, but that is always by its nature a military objective, right? As long as it is providing a military advantage, that is by its nature a military objective. But try and think now of a cyber thing, a cyber entity that might also by its nature be targetable under IHL. So I'll give you a couple of seconds to think about it, and then I'll put up one that I think meets the qualifications. So that happens to be the Cybercom Building and National Security Agency in the United States. My guess is that the infrastructure and computer stuff that sits in those buildings, when the United States is in an armed conflict with someone, those things become targetable by their nature because they are used. The nature of those computer systems and infrastructure is to carry out military attacks or military operations. Let's move on to a location. Normally, what do you think of when you think of location? Well, the one that lots of people talk about is a bridge, because if that bridge is in a place that allows the movement of military forces from a rear area, for example, to a front area, then that key location of where that bridge is might be considered a military object, or make that bridge a military objective. What do you think of with respect to cyber things? What would be, by its location, a military objective? Well, let me give you my thoughts on that. This is a building in New York City where most or much of the transatlantic communication lines come, and that communication is dispersed out broadly. That's probably because that's the location where all of that cyber communication comes and then disperses. That might be, in a time of armed conflict, the location that would become a military objective. Now, you'd still have to consider the principles of proportionality and all of the other things when you did an attack on that building, but it might become a military objective. let's talk about purpose. Purpose is often thought of as future use. So an oil refinery is a good example. That oil right there might not be serving a military objective, a military purpose right now, but it might be being shipped off to fuel tanks and airplanes. So by the purpose of that oil might make it targetable. Is there something like that in the cyber realm? Well, this, I don't know if you know this, but this is a ship that lays undersea cables, maybe undersea cables, because they will transit, particularly if they were used as part of a defense cyber infrastructure, they certainly would become military objectives because of their purpose. Last one is use. What do you think of when you think of use? Well, here's a good one. That's Rhein-Main Airport in Frankfurt, Germany, but you see the plane that's landing there in the front is United States Air Force jet. And so if Rhein-Main, if Frankfurt Airport became a military hub, i.e. Rhein-Main Air Base, then that might become, because of its use, targetable, whereas normally you wouldn't target the Frankfurt Airport. So what is like that in cyber? Well, this is, I know I'm not going to make any friends at Microsoft, but think about when a military, they're so computer dependent now, even for email, things like that, they certainly have Microsoft or other software companies on the line. Does that mean that because they use Microsoft or a specific company that turns that company into a military objective? I think that's an interesting question. In fact, let's deal with that as a scenario. So why don't you think about this scenario, and then we'll put up the poll. Go ahead and vote on this. Again, I think you probably would, if you and I were sitting in a room together, you'd have lots of factual questions for me, but just give this one your best shot. Poll coming, Karen. Oh, look at that. Wow. Okay, so pretty evenly split. That's interesting. I think that's, of course, I'm trying to give you tough questions, so I think that's great that you're evenly split. It's a tough question, I think. We could talk about the personnel in the building and whether they were directly participating in hostilities, which we'll get to in a few minutes in this slide presentation, but the infrastructure, maybe so, maybe not. I think it's a really good question to kind of, for us to consider, and one of the places where maybe cyber warfare we need to think a little bit more about. Let me give you another one of those situations. This is marking. So here's the rule on marking from Article 39. And note I've highlighted in white most of the way down the slide that if you feign civilian status and use that to kill, injure, or capture, then that can be considered perfidy. Now think about the internet and how the internet works. When we launch a missile, for example, if you're in the United States, you launch a missile, you put the United States insignia and the name on it, so that, I mean, in a sense, this serves no purpose, because wherever that missile is going to go and blow up, the people who are near it aren't going to see the markings on the missile. They're not going to know, but the United States still feels it's necessary to mark that missile because it's a bit of material, military material. Well, what do you do with cyber tools? If you're about to use a cyber tool, how do you mark it such that you're not feigning civilian status, particularly if that cyber tool might result in injury or death or capture, right? How do you mark it? It's a very difficult question. Here's what we said in the Talon manual. Let me give you a little bit more. So this is the rule. Here's something from the commentary to that rule. So again, the commentary is where we either all didn't agree or we were unclear what the law would be. Okay, so I think what we decided was, well, I know what we decided was you don't have to mark a website or an IP address as being from the United States military, but what if you're sending a cyber tool into someone's computer? Do you have to mark that? Well, the bit at the bottom says if you do that and don't mark it, and you specifically designed to deceive the enemy in order to kill or injure them, it might be perfidious. Here's a little bit more. So let's apply that to a set of facts and see what you think about this one. Okay, again, some people on both sides. So I think a literal reading of the law would say, because this isn't going to result in death or injury or capture, probably not perfidious. On the other hand, you're misrepresenting yourself, and I'm sure this would leave you with some feeling of discomfort. Now, let me just put a twist on this and say, well, what if you represented yourself as the Canadian Red Cross or the American Red Cross or the International Committee of the Red Cross? So then I think it would be definitely illegal, at least because you were misusing the Red Cross symbol, which is completely protected. Okay, let's go on. Let's talk a bit about neutrality. Here's the rule, the law on neutrality. This is from Hague 5 back in 1907. As we at Talon tried to get our heads around neutrality in a cyber environment, it was really difficult. I mean, when you send an email to someone, it doesn't all go as one place in a direct line. As I understand it, we've talked to a number of scientists in the process of this, it breaks up into little packets that divide and may go on different paths, and they kind of flow like water down a hill, the path of least resistance. Some ways you can direct them to some degree, but the vast majority of internet traffic just kind of flows as it goes and then reassembles at the IP address you send it to. So the chance of you sending something over the internet and it not crossing the territory or somehow touching neutral infrastructure during an armed conflict is really pretty slim. It's probably going to touch neutral infrastructure. So how do you deal with neutrality? It's an interesting question. Here's some of the rules that we came up with in the manual. That one seems pretty simple. Here's another one. And here's one more. Of course, the rules are simple. The difficulty is in the application. Let's try this on for size. How do you have a thought of this and see what you think? The evenness of your answer tells me I'm asking good questions. Thanks for that positive reinforcement. I appreciate that. This is a tough question, right? I mean, you could think of it simply as espionage, or you could think of it as an unlawful violation of sovereignty, if you think sovereignty is a rule. I mean, there's lots of ways you can view this cyber action and whether it's lawful or not. And these are tough questions. So I can see why you would come out differently. Let's talk, in the last topic is on combatants and civilians. The rule is Article 4 in the Third Geneva Convention. It talks about who qualifies as combatants. I left off subparagraph 6, which includes levy and mass. But here are the basic requirements of who qualifies as a combatant. Now I'm going to put up the next slide, which talks about civilians. There's some differences in opinion from various governments about how they classify members of organized armed groups, but I think this is a general consideration of them. So non-offensive civilians, of course, are completely protected. The rule is that civilians keep this protection until or for such time as they take a direct part in hostilities. And then we also understand that people who do that all the time, who are members of organized armed groups, that countries take varying views of what makes them an offensive civilian and able to be targeted, whether it's membership, whether it's a continuous combat function. There are different views on that. But let me just give you some ideas of things that are happening in the cyber realm and let you contemplate what you would do if you were the person who was making targeting decisions. Now, I haven't spelled these all out individually, so we don't have polls, but I just would invite you to think about these for a minute before I go on to the next slide and what you would decide to do. So I think these are tough questions, and whether these individuals are directly participating. I think governments and individuals can take different views, but I think they illustrate where cyber tools may make some of these questions a little more difficult. Then finally, the reason I think this is so important is we are on the cusp of the implementation, excuse me, of a number of technologies in armed conflict. Miniaturization, human enhancement, virology, autonomous weapon systems, artificial intelligence. We are on the cusp of those technological advancements being employed in armed conflict. And I think the way that we consider cyber warfare and the way that we apply the rules, the methodology by which we decide to apply the rules, will set a pattern for us in how we deal with these other emerging technologies. And so again, I'm grateful to Karen and Catherine and Samantha and the Canadian Red Cross and all the others who are involved in sponsoring this, because I think the more we think about how we're going to do this with cyber, the more we'll be prepared to handle other technological advancements as they become weaponized as well. Thank you very much.
Thank you so much, Eric, for that fantastic presentation and overview of the law of armed conflict, or IHL, as it relates to cyber warfare. We have some time for questions, and we have quite a few that have come in through the chat. I just want to remind those that are viewing on YouTube to go to Slido, that's SLI.do, and then enter the event code IHLVAN, and you can enter your questions there. So apologies to those who are asking questions, but I'm going to try and combine some questions if they're similar, just to ensure that we have enough time to get to as many as possible. So the first question, a few people asked a question about non-state actors or armed groups, and how do we ensure compliance as it relates to IHL, but also in this new world of cyber operations?
Yeah, so this is a great question, and I hope that Catherine will jump in here as well. I mean, the ICRC, among other organizations, has done a lot of work and very laudable work in trying to increase compliance, not just by governments, but by all parties to armed conflict. And this is really important, especially with cyber tools, because again, as I mentioned at the first, cyber tools are so ubiquitous. I hesitate to mention this on YouTube, but I mean, I check with hackers all the time, and I continuously kind of take the temperature. How much would it cost me to take down my university? And it's generally about $1,000. If you can buy the cyber tools for $1,000, and I can take down the university where I teach, I mean, that's an indication of how ubiquitous this is. And so there are lots of non-state actors who are going to be engaged in this practice. And we've already seen that on any number of occasions over the past 2 decades. And so this is a really important question. And it's a question that we're struggling with. Even if we say that the law applies, we struggle to get these non-state actors to comply sometimes. We need to find ways under international law to incentivize them to apply the law. And I think, again, the ICRC and other organizations are doing a lot of good. Catherine, jump in.
Yeah, that's great. I think this is a question that we struggle with as a collective, both in the cyber as well as the kinetic world. And it's a question, if you guys think, I kind of think twofold. So one, the difficulty, as Eric had said, two, you can have huge issues of anonymity, even more so on cyber. But I'd say kind of twofold. So one, if you think about that last slide of my presentation, how do we increase compliance with IHL? It's not just that single threat of accountability after the fact, but it's reminding everybody and educating and increasing awareness of the reasons and benefits of complying with IHL in the first instance. And you have ICRC who's doing work with non-state armed groups. You have other groups, for example, like Geneva Call, who work specifically with non-state actors in order to increase their compliance, looking at the use of anti-personnel landmines, the prohibition on the use of sexual and gender-based violence, the recruitment of child soldiers. So trying to work with those particular groups. And there's actually a really amazing study that's available online, and I encourage everybody to take a look at it. Even if you don't read the whole report, you can read, there's great recommendations. It's called The Roots of Restraint. And it's a study of both militaries as well as non-state actors that talk to and try to unpack the sociology of why do people comply with the rules even during times of armed conflict. And it's really so that those of us who are working in this sector can figure out how do we work with those who are possibly going to become parties to the conflict or are actively engaged in the fighting right now, and how do we speak to them, engage with them, and encourage them to comply with IHL. And there's a recognition that people will comply with the law. So think about all the instances of when you comply with the law, you choose to comply with the law, and it aligning with your community's practices, with the expectations of your family, of those who you hold dear and consider to be important in your life. That can mean for a soldier, the people who they're fighting with. And so when we're talking about the individuals who are engaged in fighting online, trying to unpack that world as well, and trying to figure out how do we engage not just on the criminal justice, because every person is, or majority of people are subject to the criminal domestic law of the country where they live. And so there's the possibility of being held accountable through that lens. But then it's also how do we increase compliance before there's a violation in the first place.
So Karen, if I could just add to what Catherine said, the ICRC and others are doing this in lots of cyber ways as well. All of these resources are accessible on the internet, but they've also created some phone apps to help as a training tool. I mean, the ICRC and other organizations are doing great work to try and disseminate this as much as they can. So kudos to you, Kath, and others.
Thanks. Actually, I could do a little plug. Canadian Red Cross and Karen worked on this project last year. We did a launch of an online platform called Force to Fight. And it's the ability to be able to go online and to be able to go through various role plays. So again, it's in trying to see yourself as a young person impacted by armed conflict, and then learning the rules about that apply to those particular situations. So making sure that we are present and people are learning through online tools as well.
Thank you so much, Catherine. Thank you, Eric. Again, I'm going to try and combine a question right now. There's a few people that are wondering about the complexity of dual-use technology. So one such example that springs to mind is social media. And then along those same lines, someone else talks about power electricity grids that also power hospitals, or, for example, disabling a country's entire civilian banking system. What's the legality behind this?
Yeah, so these are great questions. I personally don't really like the term dual use very much because I prefer to use the legal definitions in Article 52. Everything, it seems to me, that is not by its nature, in other words, like a tank, that really can only have military purposes. Everything else is dual use, if you want to use that term. For me, it means that it's a civilian object that may be used or may become a military objective. But everything else, and particularly across the internet, everything is basically a civilian object. There's very few things that are really true military objectives because of their nature. So, this is a very, very difficult question, and particularly with respect to civilian infrastructure. Now, we're going to have actually some discussion later on in this conference about critical national infrastructure, and I think that is a real key point. And the UN group of government experts, which we're going to hear about later, is engaged on this issue, and governments are trying to come to some agreement. But it certainly reflects an area of risk involved for governments, and particularly with respect, again, to non-state actors and others who, with the ubiquity of the internet, that are at risk in those areas. So it's a great question. I wish I had a more comforting answer, like it's all solved, we've got that worked out, no one's going to ever attack those things, but unfortunately, that's not the case.
Karen, just to build on what Eric said, yeah, there's so much debate and discussion, but just to build on, so Eric had mentioned about that nature, purpose, location, and use, so relying on our legal definitions. The person had asked about the damage to the civilian infrastructure, in particular on hospitals. And that's a question definitely from the Red Cross and Red Crescent movement. We're asking those who are participating in the hostilities to consider that impact in, for example, their proportionality analysis. So your distinction analysis first says, can you target, can you not? But if, let's say you can target, you then have to do your proportionality analysis that looks at, reminding us again what the law says, that concrete, that looking at the military advantage, but looking at the civilian damage and the civilian infrastructure that can be lost as a result of that, and very much encouraging states and asking them to be aware of the impact of that on the civilian infrastructure. There's two great reports about that if people are looking for further research and writing. A proportionality report from a workshop that was held at the University of Laval. And so you can see within that kind of the debate and discussion that flows from a proportionality analysis, and that's both kinetic as well as the cyber, and then also a report put out by Chatham House, also again unpacking that proportionality discussion, which I think, like Eric's polls earlier, you're going to see a lot of debate and discussions in that. So definitely one that is a live issue, but nevertheless, from a movement perspective, very much reminding states of their obligations to do that analysis and looking at the impact, regardless of whether it's cyber or kinetic, the impact on the civilian infrastructure and the damage to civilian infrastructure and the loss of civilian life.
Thank you so much. We had a couple of attendees wonder about 5G technology and if this potentially increases cybersecurity risks.
Yeah, so I am not a computer scientist, so I'm talking to you based on what I have talked with computer scientists about. And I think that, like every piece of technology, it provides opportunities and risks. So does 5G provide increased risks? Absolutely, it does. But does it put, I guess my question would be, does it put things beyond the scope of what we can cover with IHL? And that I would say no. I'd say that there's nothing in 5G technology that makes it impossible to apply the law of armed conflict in those cases. And so I think we can continue to have faith that the law of armed conflict is carefully crafted and will advance even to 6G, whatever that will be and whenever that will happen. and that where there are places where we need to evolve the law, we will be able to do so effectively.
Thank you. We have a question from Kayla. She asks, when drafting the manual, Eric, how did you and your collaborators find the balance between ensuring applicability and keeping the rules broad enough to apply to evolving technologies?
Yeah, it's a really good question, and it was really a difficult thing for us to do. When we started to write the manual, we set out with the strong commitment to only explain the law as we thought it actually was. The lex lata, not how we thought the law ought to be, the lex ferenda. For example, the question of data. Is data an object that is targetable? We examined all of the current case law and came up with the decision that under current law, data, probably computer data, electronic data, is not considered an object with respect to targeting. Now, none of us like that decision. We all think that data should be protected and that states will eventually accept that. But that's what we believe the law currently said when we wrote the manual. So we tried very hard to stay to our mission and our scope, and it was in fact difficult, but I think we did a pretty good job of that.
Thank you so much. And again, I'm going to have to cut the Q&A short. I know that there are several more questions that have come in, and we want to try and answer those towards the end of the conference. But just really quickly, Eric, someone is wondering if your slides, are you able to share your slides? Sorry to put you on the spot. If someone wants to read them again.
Oh, happy to. So you can either reach out to me specifically directly, I'm happy to, or Karen's got them as well. I'm happy to have you have a PDF version of the slides. You're welcome to them.
Great, thank you. So whoever asked that question, it came in anonymously, just send me an email after and I'll share the PDF version.
So maybe, Karen, I should say you can only get the slides if you send me back your answers to the questions, because I'd be very interested in knowing what you thought.
Right. So you have to complete a short quiz and then you'll get access to the slides. Perfect. All right, so we're gonna take a quick or a short virtual break. We'll come back at 2:40 Vancouver time. When we come back, my colleague Samantha will be taking over as moderator, and we're going to have our panel presentations. So just quickly introduce Samantha to you. Samantha currently works with the Canadian Red Cross in risk reduction as a violence prevention educator and instructor training. Samantha's been involved with the IHL conferences in Vancouver for the past, I think, 4 years now, and she will be moderating the next portion of our conference. So welcome, Samantha, and thanks everyone for your active participation. If you want to take a quick break and go get a coffee and meet back here at 2:40 Vancouver time. Thank you.
Right, hello and welcome back, everyone. I hope you had enough time to have a quick health break, and thanks for joining back with us. I'm Samantha again. Karen introduced me before the break, and I have the pleasure of introducing our next speakers. We have a panel talking about the contemporary challenges with cyber warfare, and we've got 3 different speakers that will be joining us for this panel. So quick introduction on each of them, and then I'll give them some time each to discuss specific topics. So first up, we've got Paul Meyer. He is an adjunct professor of international studies and a fellow in international security at Simon Fraser University. He's also a senior advisor to ICT for Peace and has served as chair of the Canadian Pugwash Group since 2017. Mr. Meyer has also had a 35-year career with the Canadian Foreign Service, specializing in international security and policy as a diplomat. Following Paul, we've got Ichiamaka Anika. She's a PhD student at the Peter A. Allard School of Law at UBC. Her research focuses on international and transnational criminal law, including how the use of cryptocurrencies may facilitate transnational crimes. And then finally, we'll have Ahmed Al-Rawi. He is an assistant professor of news, social media, and public communication at Simon Fraser University, and a senior research affiliate at the Canadian Network for Research on Terrorism, Security, and Society. His career in media has included working with various news outlets and as a spokesperson for the International Committee of the Red Cross in Iraq. So first up, like I said, we have Paul Meyer. I'll turn it over to him to talk about the search for cyber peace.
Thank you, Samantha, and thank you, Karen, for getting the first slide up. You know, we hear so much about cyber warfare these days, it's including at this conference, so it's healthy to have some discussion about cyber peace and to remind ourselves that it too can be a goal of states and non-state actors alike. Certainly, the NGO I'm affiliated with, ICT for Peace, is dedicated to this goal. In addressing the topic of norms of responsible state behavior in cyberspace, I will start from describing some irresponsible state behavior, in particular the cycle of action and reaction that is militarizing this unique human-created environment. Ben Buchanan of Harvard University has described the situation as creating the cybersecurity dilemma, the cyber equivalent of the long-standing concept in international relations of the security dilemma, whereby one state's actions to provide further security for itself prompts reciprocal action by other states, which results in diminished security for all. This dynamic is exacerbated by a particular feature of cyber operations, whereby, in Buchanan's words, quote, "From a defender's point of view, it is nearly impossible to separate an act of espionage from preparation for war." So after this brief survey of an increasingly militarized cyber landscape, I will turn to the relatively leisurely diplomatic efforts at the UN to develop norms of responsible state behavior. And I'll conclude with some suggestions as how the pursuit of global norms might be reinvigorated and redirected. Next slide, please. The fundamental question about this powerful new human-created environment, whether it should be a realm of peace or a domain of war, is still outstanding. As the internet and its users grew in size and strength, governments slowly became involved, bringing their particular concerns and priorities, security prominent among them, to this novel environment. At this early stage, there may have been opportunities to enshrine a for peaceful purposes only policy for cyberspace, akin to what had been done via international agreements for other unique environments, such as outer space, Antarctica, and the seabed. But this option was not pursued. Instead, we had the national security establishments of leading states project an adversarial struggle onto this arena, and opt to develop capabilities for cyber conflict rather than explore possibilities of cooperative security. We have thus seen in recent years the emergence of state conduct that threatens the well-being of humanity at a vast new scale. The description on the slide from Alexander Klimberg's book aptly describes the scope of the threat the state action can represent for the billions of netizens who rely on the functionality of cyberspace. It is a threat no longer confined to traditional destructive weaponry, the so-called kinetic effects in military parlance, but now embraces a new information warfare element that is especially damaging for open societies. Next slide, please. The militarization of cyberspace has come about rapidly and without much in the way of public debate or political direction. This in part relates to the origins of state-conducted cyber operations within the intelligence agencies that have always operated under a thick mantle of secrecy. Their objectives of intelligence collection through covert penetration of foreign computer networks stress the exfiltration of data without alerting the victim in the process. The same capabilities, however, could be used to disrupt or destroy data and indeed systems, and soon the military became engaged. The US Cyber Command was set up in 2010, and it wanted to normalize cyber operations by situating them within an accepted doctrinal framework. Hence the assertion that cyberspace is just another domain for warfighting alongside the domains of land, sea, and air. It is noteworthy, however, that even the military seems aware that this usage of cyberspace will be contested by some. And the Cyber Command's policy document, a quote of which is on the slide, blames the militarization of cyberspace on the other guy who started it first, claiming that the adversaries had done this already. Next slide, please. This chart is taken from the US Director of National Intelligence Worldwide Threat Assessment and marks the growth of the number of states possessing offensive cyber capabilities. From less than a handful of such states in 2007, the ensuing decade has witnessed a steady growth of such capacities, with over 30 states now judged to possess these offensive capabilities. The assertion by states of such capacities has not been clear-cut, as several have been reluctant to acknowledge possessing cyber capabilities that go beyond the purely defensive. In a desire to depict these new areas of operations as essentially benign, some states have recourse to various euphemisms. For example, the Canadian Defense Policy Review Outcome document, released in June of 2017, states that Canada, and I quote, will develop the capability to conduct active cyber operations focused on external threats, end of quote. While for the layman here, switching on your computer in the morning is an active cyber operation. So why should we be alarmed? We're going to skip the next slide, please, Karen. And yes, thank you. So here is an attempt to illustrate the escalating pattern of malicious activity. I've listed here some of the most prominent offensive cyber operations attributed to state conduct in recent years. And to note, as Eric has already alluded to, there's a big difference between so-called distributed denial of service attacks, DDoS attacks that have occurred, for instance, against Estonia and Georgia, which temporarily crash government websites, but which did not destroy or distort data, and those sorts of cyber attacks that entail deliberate and extensive damage. For instance, the Stuxnet worm that was directed against the Iranian nuclear program was the first cyber payload that caused the physical destruction of its target. In this case, the centrifuges being used to enrich uranium. And it can be considered in a way the first cyber weapon employed by a state. Although never formally acknowledged, In the summer of 2012, there were numerous leaks from US officials detailing this joint US-Israeli operation codenamed Olympic Games. And ex-CIA chief Michael Hayden compared it in its significance to Caesar's crossing of the Rubicon for the offensive use of cyber down the road. It also means that US claims that it was America's adversaries who first militarized cyberspace will be met with a certain degree of skepticism. Next slide, please. The UN first turned its attention to the potential destabilizing effects of information and communication technology. ICT is the acronym the UN tends to favor, in the fall of 1998, when the General Assembly adopted a resolution sponsored by Russia that expressed concern that these technologies could be employed, quote, for purposes that are inconsistent with the objectives of maintaining international stability and security and may adversely affect the security of states, end of quotation. So ever since there have been resolutions and activities under this rubric at the United Nations. And while there are occasional calls for new legally binding agreements to govern state activity in cyberspace, the principal trend has been in the direction of identifying certain norms of responsible state behavior. The United States, under the Obama administration, was arguably the first country to recognize in its official policy the necessity for a global response to the threat of conflict in cyberspace. In 2011, it issued an international strategy for cyberspace, which acknowledged the requirement to build a global consensus around a set of principles or norms for states to follow. While the policy suggested that the US would assume a leadership role in this effort, the Obama administration was never able to develop an effective diplomatic strategy to realize the goal. The revelations of Edward Snowden in the summer of 2013, which exposed a massive US cyber surveillance and intelligence gathering program, did not exactly provide a conducive environment for advancing an international dialogue on norms and trust. Next slide, please. At the United Nations, the principal mechanism for discussing cybersecurity norms has been groups of governmental experts, GGEs, created by the first committee of the UN General Assembly. That's the committee that deals with international security and disarmament matters. These GGEs normally consist of 15 to 25 nationally nominated experts that study a specific issue over a 2-year period and then offer up a report and recommendations for UN member states. The GGE will only issue a report if there is a consensus agreement on the part of all its representatives. All of the consensus reports, i.e. the ones arrived at in 2010, 2013, and 2015, have recognized that states have an interest in preventing conflicts arising from the use of cyber technology, and that, quote, international cooperation is essential to reduce risk and enhance security. The reports have supported confidence-building measures to, quote, increase interstate cooperation, transparency, predictability, and stability. In the 2015 iteration, these have included restraint measures, such as the non-targeting of critical infrastructure upon which the public depends, or states' computer emergency response teams, the sort of first responders to cyber incidents. A key area that remains unresolved is how exactly should international law be applied to state cyber conduct. Is it appropriate to consider cyberspace a warfighting domain, or should it enjoy some other status? Some states have resisted the application of the laws of armed conflict to cyberspace, arguing that this would legitimize the use of cyber force in this special environment. This has posed a policy challenge for the International Committee of the Red Cross, which has affirmed the applicability of IHL to cyber operations during armed conflict, while hastening to add that such an affirmation, and I quote, does not legitimize cyber warfare or encourage the militarization of cyberspace. End of citation. So although the GGE process yields some important findings, the very nature of this mechanism, an appointed limited subset of UN members that carries out this work behind closed doors, has prompted criticism. Besides general GGE fatigue, some observers are concerned that 16 years after the initial GGE on this subject, states are exploiting the process rather cynically to suggest their commitment to higher goals of cooperation while doing little in practice to alter their actual cyber behavior. Next slide, please. The tensions among rival cyber powers that are increasingly evident were vividly manifested at the UN General Assembly in the fall of 2018, when two competing resolutions, one sponsored by Russia, establishing a new open-ended working group, and one by the United States, which supported continuing with a traditional GGE. Instead of the normal expectation that two sponsors would cooperate to produce a compromise text and a single resolution for the Assembly to consider, necessary flexibility was absent and both resolutions were pressed to a vote. In its wisdom, the General Assembly adopted both, even though the mandates were overlapping and the requirement for the UN to support two parallel processes would be a drain on limited resources and strain policy coherence. Both processes aim to produce consensus outcomes, but the open-ended working group with its greater transparency and inclusiveness is garnering most attention. In particular, has provided the first occasion for a meeting with non-governmental stakeholders. This vital input might inform the open-ended working group's report, which is due in July, in order to recommend tangible measures. Some of the proposals that ICT for Peace has put forward include establishing a peer review mechanism modeled on the Universal Periodic Review of the UN Human Rights Council that would provide a regular means to hold states to account for their international cyber operations. There's also been a call for governments to publicly confirm that they will respect the 2015 GGE norm not to target any critical infrastructure. The current posture of leading states is not auguring well for a productive outcome from these processes, but we believe that cyber peace is worth championing and will need to develop an active cyber peace lobby to ensure that. I think I've run out of time, so I'll end it there, but I'll welcome any questions. Thank you.
I'm just going to add, please submit your questions in the Q&A section, and we're going to move forward with our next two presenters, and then at the end come back with our panel to answer any questions that you might have. So thank you so much, Paul, for that. And we're going to move on to Ijeamaka, who's going to be speaking about international and transnational criminal law. Thanks.
Okay, thank you. I'm just going to share my screen. Spare me one moment while I do that. Karen, I might need you. Oh, right, yeah, share screen. I found it.
Sure, I'll share from my end.
Okay, I think I found it.
Oh, you got it? Okay.
Yeah.
Oh, perfect.
Yeah. Okay, hello everyone. I'm going to slightly shift focus a little bit with my presentation because I will be focusing on transnational crimes and financial technology. So the role of cryptocurrencies, more specifically in facilitating transnational crimes. So I'll just start briefly with a quick definition of transnational crimes. And for this, I'm going to go to the United Nations Convention on Transnational Organized Crime, where it states that transnational organized crimes are crimes that are committed in more than one state. They're crimes where the preparation, planning, direction, or control takes place in a different state, but a substantial part is committed in another state. Transnational organized crime can also involve an organized criminal group that engages in criminal activities in more than one state, or where a crime is committed in one state but has substantial effect in a different state. So I'm just gonna hold this down so I can see my. Okay. Okay. So in terms of transnational organized crimes, some of the key forms of transnational organized crimes that are usually recognized in most transnational crime conventions include money laundering, terrorist financing. Just because of the focus of this conference, I'm just going to spend a couple of minutes just talking about terrorist financing, because I feel that that is the one that kind of signals a little bit where cyber warfare could come in with cryptocurrencies and financing cyber warfare. So with terrorist financing, the provision of financing for terrorist activities is recognized as a transnational crime. And there is an international convention on the suppression of the financing of terrorism, which defines terrorist financing as a situation where a person commits or aids the commission of terrorism through finance with the aim of furthering some other criminal activity or purpose. Notably also, the Financial Actions Task Force extends its anti-money laundering mandates to the fight against terrorist financing. And to operationalize this mandate, it adopts special recommendations to add to the initial recommendations that it already has. And I will explain these instruments in a little bit more detail towards the end of the presentation. Additionally, with regards to terrorist financing, the UN Security Council post 9/11 adopted a resolution aimed at the prevention and suppression of financing of terrorism. And in that resolution, the Security Council noted that there is a nexus between international terrorism and transnational organized crime, such as drug trafficking, money laundering, trafficking in arms. And so you can see with the little list that I have on the slideshow, it reflects how interconnected all these crimes are. And in that resolution, the Security Council highlights the importance of coordinated efforts amongst national, international, regional agencies in order to strengthen the global response to serious threats to the international society. So with the rest of them, so human trafficking I mentioned already. With regards to cyber warfare financing, what I am doing is making this analogy because it's not expressly included in any of the transnational crime conventions, but I can see how these conventions can be interpreted in the context of cyber warfare financing, and especially with regards to the Convention on Terrorist Financing. So this could be, for those that are interested, an area for further research. I think about hacker communities and paid denial of service attacks and how these could be financed using money that is either laundered through various means, including the topic of my presentation, cryptocurrencies. So I want to talk a little bit about money laundering because of the central role that it plays with transnational organized crime. So money laundering is a financial crime. It disguises the illegal or illicit origins of wealth to avoid suspicion of law enforcement agencies. I have on the screen the definition of money laundering according to the UN Convention on Transnational Organized Crime, and this definition is reflected in a couple of other anti-money laundering regulations. So with money laundering, I mentioned that it facilitates other transnational crimes. So with the transnational crimes that I mentioned, they all seem to have a relationship with money laundering, either as predicate crimes or as post-dictate crimes. So what I mean by this is these are the predicate crimes are crimes that are often committed before the need for money laundering arises, and the post-dictate crimes reflect crimes that are committed using laundered funds. And the idea is that whether the crime is committed before or after the laundering activity actually takes place, the aim is to conceal or disguise the true nature, source, location, origin of the funds, so that whoever it is that is facilitating the commission of crimes can either obtain the proceeds of the crime and use it in society, or use it in the furtherance of other criminal activity. So with post-dictate crimes, I'm thinking about terrorist financing. So I just wanted to mention some of the regulatory efforts to combat transnational crimes, including money laundering. So I have sorry, one second. I have sorry, 1 second, please. Sorry, one of the hazards of trying to join a conference with a 4-year-old by my side. So with transnational regulatory efforts, they are all centered around the prevention, the prosecution of transnational crimes and international cooperation to achieve these aims. So I've mentioned briefly the UN Convention on Transnational Organized Crimes, the Convention for the Suppression of Financing Terrorism, and the Financial Task Force has recommendations that are all aimed at preventing and prosecuting transnational crimes and also international cooperation to achieve that objective. And the key components of these regulatory regimes are to require from states domestic efforts to criminalize money laundering and participation in organized criminal groups or activities, to monitor and detect money laundering and the transnational crimes that they facilitate, and to recognize that serious crimes are predicate offenses to money laundering. And in this regard, because of the financial component with the money laundering, there is a heavy burden placed on financial institutions with regards to monitoring and reporting suspicious financial activities. So when these instruments talk about prevention and prosecution, they usually require a lot of commitment from financial institutions. So now on cryptocurrencies, states and international organizations are beginning to realize that technology is playing a huge role in expanding societies as we know it. And as our societies become smaller through technology, criminal enterprises and criminal actors also exploit these tools to commit transnational crimes and other criminal activities. So cryptocurrencies they are considered a financial technology. They are also convertible financial assets because you can have cryptocurrencies and you can convert them into fiat or real money. Obviously, the cryptocurrency that most people are aware of, Bitcoin, is steadily gaining momentum in the real and virtual world. As it's growing in use, there remains no formal oversight of cryptocurrencies or cryptocurrency exchanges. The cryptocurrency exchanges serve as intermediaries and facilitate buying and selling of cryptocurrencies. But there remains no kind of like formal oversight to monitor their use or to regulate their use. There are a lot of anonymizing tools with cryptocurrencies that make them susceptible to money laundering. And this calls for some form of regulation to kind of like close the gap that may allow criminally minded actors to exploit the use of cryptocurrencies. I think I may be nearing the end of my time, but I'll just mention quickly why it's important to regulate cryptocurrencies. The first one is that there is already evidence of its use for criminal purposes. Silk Road is a key. Silk Road is a key. I want to play with my turkey. This is turkey. Silk Road is a case that involved many governments and many regulatory agencies working together to combat the use of Bitcoin in an online marketplace for drug trafficking and for human trafficking. There is also currently evidence that cryptocurrencies are being used to finance terrorist activities. And beyond that, there are also criminological theories that I draw on in my research that suggest that increasing the displacement of traditional means of money laundering may lead to money laundering through alternative means, such as cryptocurrencies, because they remain relatively unregulated and there is no oversight. So bringing cryptocurrencies within the existing anti-money laundering framework, as I was listening to Professor Jensen and describe the Tallinn manual, it occurred to me that what I have done in my research is kind of like a basic attempt to reinterpret the anti-money laundering framework in a way that it is applicable to cryptocurrencies. So for instance, in my work, I look at where the Convention Against the Financing of Terrorism criminalizes the provision or collection of funds by any means with the intention that they are used for terrorist activities. So when it talks about funds by any means, I think about cryptocurrencies and whether they could be considered funds. And in my view, they could be interpreted as funds if you look at some of the characteristics, especially the financial aspects. And the CFT also defines funds as assets of every kind. So if you don't consider them funds, when you go beyond that criminalization and look at the definition, you can see that they should definitely count as assets of every kind. I know that I may have overrun my time, but yeah, just in conclusion at this point, I would like us to think about, for those that are interested and those that are familiar with the anti-money laundering framework, how can this framework, the different instruments within this framework, be reinterpreted in a way that recognizes that technology is being used in the perpetration of crimes, and how can these instruments apply in the context of cryptocurrencies, as I do in my work. Thank you.
Thank you so much, Ejimeka, for that insight. That was great. All right, next up we have Ahmed. He's going to be speaking about cyber warfare in the Middle East. And just remember to submit your questions for the Q&A period just after this. Thank you.
So welcome everyone. I just need to share my screen, please. So just give me 1 minute. This will work. Yeah, it looks like it's working. Excellent. Perfect. So welcome everyone. Thank you for attending, and thank you Karen and the other committees and the other committee members and the Canadian Red Cross for inviting me to talk about cyber wars in connection to IHL. My presentation today is related to cyber war in the Middle East. Now, just a few things before I start. I know I have about 10 minutes to talk, but I just need to mention I'm not a law expert. So I wish I were like Catherine and Eric. I wish I were like them, very much knowledgeable in IHL and laws. But so my presentation today will be mostly focusing on cyber war from a communication perspective, because this is my area of expertise. So that's how I'm going to tackle it. And I'm going to question, the first thing I'm going to ask is, what is cyber war? I know there has been, I mean, Eric, I think, talked about it in some details in relation to the talent manual. Very interesting discussion. But for me, cyber war should be a bit expanded upon. What is an online armed conflict? This is another thing that I don't think IHL covers it in details, and that's my argument. I'm saying that we need to look at cyber war in a different way, and how it's being implemented or used today in different ways. So I'm also connecting what Paul mentioned regarding disinformation, the Russian disinformation during the 2016 US election. So I'm picking the word disinformation, and I am connecting it to today. I mean, the fact that we are talking online today is because of COVID. And during these times, we have a lot of disinformation happening about COVID, including, for instance, that, of course, it's a wrong claim that COVID-19 was designed by the US military in order to attack or in order to influence China. This is definitely disinformation. So what I'm arguing here is that this kind of disinformation is one aspect of cyber war. In other words, we are living in an ongoing cyber wars that is happening in different ways on different levels and dimensions. And that's my argument today. And I'm sure that maybe other people will be, asking me questions about, hopefully asking me questions about it, but this is again my argument, not from a legal law perspective, but from a communication perspective. Okay, so I'll begin with this, this model. So this is a model that I have developed in order to explain what a cyber war is. It's a bit complicated, I think, but what I'm saying here is that cyber war functions in different dimensions. So we start from the top. We have nations attacking other nations. And I call this a horizontal flow of attacks or communication. They have equal powers. They attack each other. And when I talk about powers, I mean cyber tools. So Eric in the presentation talks about a cyber tool. In my mind, it's a cyber weapon. That's how I see it. If they have spying tools, then this is a spying weapon. I don't call it a tool, I call it a weapon, because there is a big difference here. It's just a name, but if you call it a weapon, then this is a war. And this is what I see in my mind. So what I'm talking about here is a model that could explain how a cyber war is happening today. So we have nation states attacking other nation states. Now, what is interesting about this scenario is the fact that many nation states that have valid or ongoing diplomatic relationships still attack each other online. So in the offline world, they look very friendly, they look very happy collaborating amongst each other. But in the online sphere, it's a completely different story. Like, for example, when we talk about the Chinese hackers versus US hackers. So we have some kind of tension going on, or Russians on the one hand and the US on the other hand. So this is what I'm saying here, that on the surface or in the offline world, we have maybe friendly relations, but in the online world, it's a completely different thing. Now, in the middle, we have cyber warriors, as well as the global hacking groups or hacktivist groups. So just a definition, a cyber warrior is supposed to be groups that are affiliated with nation states, and they are still involved in serving these nation states, either for financial reasons or probably for political reasons. So what we have here is we have also what we call vertical flow. So a nation state might attack citizens, and this is where I will connect IHL in the last slides. And this is one kind of vertical flow, because usually these nation states have powerful cyber weapons, and they will be able to attack citizens. They spy on them, they take information from them, and so on. So citizens have, most of the cases, they are cornered. Most of the cases, they have no power to defend themselves or even to attack back the nation states. And we have, of course, in the middle, independent hackers who might have some kind of digital, let's say, skills to attack nation states, their websites. But in most cases, they have, let's say, less impact, less power than that nation states have. So this is, again, my model. And what I'm also adding to this is the fact that we usually have in cyber wars 3 dimensions. So we have the international scope, we have the regional scope, and we have the local one, which is the internal one. And that's, again, how I am building this model based on these 3 types of scopes. So just a reminder, my case study is the Middle East. I'm from the Middle East, so I'm more familiar with it. I have just written a book, which is now under review, about cyber wars in the Middle East. So the cases I am going to present to you are all from the Middle East. However, you can easily apply it to different contexts, to different, let's say, regions, easily. In my view, you can easily do that. So I'm going to show you some examples of what I call ongoing cyber wars happening in the Middle East, based on these 3 dimensions: the regional, the local, as well as the international. So this is one example from the regional dimension. Now, in my presentation, I am presenting to you empirical findings. I look at raw material, raw data, and I try to find, let's say, some evidence to present to you. So take this, for example, this is taken from what Twitter released regarding the Emirati and Egyptian trolls. These are political trolls. These accounts were all deleted, but the data set is available, freely available. So when I was looking into the images that they were, were posted, I found this interesting one. This is in the middle is the Al Jazeera channel logo in Arabic, and they are attacking here the journalists of Al Jazeera channel. But because for Egypt as well as the UAE, Qatar, which in which Al Jazeera is based, is their opponent, and you can see this even in the offline world. And they are doing a lot of trolling attacks against the Emir of Qatar, as well as its symbols, including Al Jazeera. Because for them, Al Jazeera is the mouthpiece of the Qatari Emir. It has to be attacked. And of course, here they have, this is the connection I'm making here. Notice here the flies. In the Middle East, they refer to trolls, political trolls, as electronic flies. And they regard it as users, people who are paid in order to serve certain agenda or to serve certain nation states. In other words, they are accusing all of Al Jazeera journalists, correspondents of being electronic flies serving the interest of Qatar itself. So what we have here is a group of countries attacking each other within the same region. To give you more example, this is the opposite. This is a Qatari pro-Qatari Twitter user trying to highlight on Twitter someone who seems to be serving the Saudi. So again, here in the comments, it says, oh, look, we need to tag this user, highlight this user, because she seems to be an electronic fly. They even use the hashtag in Arabic, electronic fly. So again, in my mind, this is like a war, an ongoing one. So we have communities, some of them supported by the government, by their own states, others are not supported, who are attacking each other. This is another thing that is being done on Twitter again. They use, especially the Saudi, there is even the Saudi electronic army. They use the spam feature on Twitter in order to encourage Twitter to remove their opponents from the whole platform. So what they usually do, notice here, for example, they say, oh, this is ISIS, but this is simply someone, I think this is from Yemen, or someone like an activist that the Saudi government does not want to remain on the platform. So what they usually do is reporting specific users, accusing them of extremism, terrorism, only for driving them outside the platform. Again, in my view, they are weaponizing, exploiting some of the weaknesses of certain platforms in order to serve their own purposes. This is another one. Do you support team tagging a few users? This is again done in a very coordinated, organized way by the Saudi Electronic Army. They call themselves, by the way, the Salmani Army, which is a reference to the Crown Prince Salman bin Mohammed. This is another example. They are, for instance, this Twitter user is instructing, teaching, guiding other spammers on what to do, how to report. So here they are giving them advice. Reports say that, oh, this is abusive, harmful language, or there is harassment or violence, and so on. And because the purpose in the end is to block a user from the platform. And that's exactly what they want. They want to block all their opponents and remain active on the platform so that they can, so that their voices can be heard rather than their own opponents. Again, I'm theorizing here is that this is a cyber war being manifested in different ways. Now, this is one way of doing it, but another way is by with the use of hackers. And of course, here hacking, I think Eric gave an example about how to, there are tutorials on YouTube on how to hack websites. But there is, like in the Middle East, there are large number of hacking groups very active in defacing websites from different regional countries. So this is one example. This is an Iranian website that was defaced by a Saudi hacker group called Crazy 3R, something, I don't know what, even the name is crazy here. And notice here the nationalistic, chauvinistic, let's say, elements that we have here. Grabbing an Iranian mullah or an Iranian religious leader. And there we also have the Saudi flag. But this is not only done by one side, it's done by different sides. And this is, let's say, another counterattack by the Yemeni cyber army against a Saudi website, picturing the Saudi king as if he is in hell, with one citation from the Quran to condemn the Saudi king. Just one comment about the Yemeni cyber army. There is evidence that shows that it is not actually a Yemeni cyber army. It's an Iranian one, especially because of the sophisticated techniques that they have and the cyber weapons that they've developed. So talking about the international dimension, I just covered the regional. I think I have a few more minutes to finalize my presentation. This is an example of the international dimension with regard to the Middle East cyber wars. I took this from when I was browsing CBC News, I think it was 2015, and this is an attack by the Syrian Electronic Army that is very affiliated, connected to Bashar Assad regime. And they have hacked the CBC app in this case. Now, why did they do that? In my view, they are trying to show that they are powerful, they are tech savvy, they are well advanced. So it's just like it's propaganda for them, trying to show off that they have the technical abilities to inflict harm on international, let's say, sides. So another example of international dimension is the recent report that the Saudis hacked Jeff Bezos. As you know, the Amazon, CEO of Amazon, using a cyber weapon borrowed or taken from an Israeli company. So that's in my view another example of the international dimension of a cyber war. This is cyber war because they intentionally attacked Jeff Bezos because simply because Jamal Khashoggi, the famous Saudi activist, used to work as a columnist, a journalist for the Washington Post, owned by Jeff Bezos. So it's a political, it's done for political reasons. The local dimension, this is an example from Iraq, where I am showing you here an Iraqi hacker called M4X Pro, or probably an hacking group, hacked the websites of certain websites from Iraq because they wanted to object to or protest against the government position regarding the protesters and for detaining one of the activists. So it could also be a local dimension. And the local dimension is also manifested in the other side when the state surveys or spies on its own citizens. So we have so many examples from the Middle East on this aspect. For instance, in Bahrain, the Bahraini government uses spying tools to monitor activists. Some of them actually were captured, tortured, and even killed. In Saudi Arabia, we have the same thing. And they even monitoring, for instance, Omar Abdulaziz, the famous Saudi activist who lives in Montreal here in Canada, had his phone spied on by the Saudis as well. So this is all in my own model, part of the local dimension. Most importantly, Jamal Khashoggi, the journalist I have just mentioned, he was also trolled and he was spied on by the Saudis. And as you know, he was unfortunately killed also inside the consulate. I'm still working on this, but I found something interesting that I want to share here is that in the fact that when I looked at the Twitter datasets released by Twitter itself, which contains about 29 million tweets, I specifically looked at the way they attacked Jamal Khashoggi before and after his assassination. And I found something that was, in my mind, very shocking. I compared the timing. So Jamal Khashoggi went inside the consulate at 1:15 exactly. At 1:45, and I compared the timing, 1:45, which means exactly half an hour after he went inside the consulate. There was a campaign that was initiated by the Saudi trolls with the hashtag Khashoggi scandals, a very coordinated, organized campaign that started exactly half an hour after he went into the consulate. I find this to be very much organized, well-planned in advance. Again, this is something that has not been published before, but I'm working on it, including another hashtag, hey Erdogan, where is Khashoggi? Yeah. So Samantha, do I have one more minute or? 1 more minute, excellent. So this is my last slide. So what I'm arguing here is that when it comes to IHL and the cyber wars, we need to probably expand a bit on this. I know that Eric said IHL does cover, or it has all the elements or all the necessary, let's say, details with regard to cyber wars. But I think there should be something clearly stated in IHL about cyber wars, especially when it comes to the protection of civilians in authoritarian states. That's my argument. So I'm saying here the cyber dimension and armed virtual conflicts need to be clearly incorporated instead of just like generally stated, and then it should be probably generally interpreted by legal experts. Thank you very much for your time, and yeah, hopefully we'll have some questions. Thank you.
Thank you so much. That was great. Yeah, we've actually got quite a few questions, so I'm going to jump straight into them. First one is from Fatima, and I believe this is directed towards Ijeamaka. What type of measures could be used to regulate the use of cryptocurrency? Would it be regulated at the national level or the international level, in your opinion?
Okay, so in my opinion, it's a combination of both. So at the international level, it's important for there to be a framework regulation, which then trickles down to the domestic level. So with what is happening with the existing transnational organized crimes, how that works is that there is a framework regulation, so the conventions, and then state parties have to domesticate these provisions and reflect them in their laws. So I believe it's a multi-level approach of regulating at an international level and then at a domestic level. I hope that answers the question.
Yeah, thank you. If any of the other speakers feel like they'd like to add to some of the questions, definitely turn on your screen and let me know. But for the sake of time, I'll just jump through before opening it up to everybody else. Okay, next question is for Professor Meyer. Do you think Canada is prepared for a cyber attack?
Oh, I mean, we have establishment, communication security establishment that has among its responsibilities the defense of Canada's cyber capabilities and infrastructure. But we also have seen that no major organization, be it in the public sector or the private sector, seems to be immune from being victimized by cyber attacks, which is one of the reasons why I would like to see much greater regulation of acceptable action in this realm. You know, there are different ways of approaching a problem, a threat. You know, one is you can only deal with defense. Some you can only look at through deterrence, but there's also some where you can apply diplomacy and actually remove some of the threats that you face, and provide coalitions of like-minded who are willing to contest then those bad actors who aren't prepared to go along with cooperative measures.
Thank you. This is for Ahmed. Do you have a comment on the rise of the far right on social media here in North America? Do you think this could be considered an act of cyber warfare?
Oh, thank you. Well, they say that. They actually talk about it being cultural war. This is what they say, and I'm doing research on that now, empirical research. So basically, it's a war. Even on Instagram, I'm doing another study. I have actually finished many studies on Instagram. They call it the memes war. So they have the first meme wall, the first meme world war. That's when they brought Donald Trump to power. The second memes world war is when they are trying their best to keep Donald Trump in power. And that's most of the far right. Yeah, they call it a war. It is actually happening all the time. It's ongoing without stopping.
Thank you. So to continue that, Catherine, do you want to add?
Yeah, and I think, Ahmed, just to reply to some of how you were framing it, as when you're talking about the use of the word war or armed conflict, realizing that it can be used in some settings to imply kind of that active engagement. So, for example, talking about far right or yeah, one of the extremes on any of the social platforms. But then I think it's also super important for us to make sure that when we're talking about whether or not we want the rules of IHL to apply to that particular scenario, that's where we have to, I would argue that we want to make sure that we're making that determination really carefully. Because as we know, for example, from Eric's presentation and my presentation, the ability to be able to use force during times of armed conflict is much greater than during times of peace. And we have seen scenarios, and yeah, for example, I'd seen one of the questions about the war on COVID, the war on terror, and a reiteration within the humanitarian legal community saying that it's of course you can use that language to describe the scenario, but from a legal perspective, you still have to do the analysis to make sure you then arrive at a conclusion that it is in fact an armed conflict. Because as soon as from a legal perspective, it is an armed conflict, then you have the rules changing about the use of force and protection that's afforded. And I actually wanted to ask Eric if maybe in some of the discussions about in Tallinn, if you guys had talked about or unpacked some of that changing language or the ability and reflex to use language on cyber warfare, but on attacks that maybe didn't meet the threshold.
Yeah, I'd be happy to address that. Samantha, do you want me to address that now, or?
Yes, please. Well, I've had a few questions that have asked in various ways. Do you think we need to add to the law to cover cyber warfare more thoroughly? Do you think the law is sufficient as it is? And these questions were worded in different ways and directed at every one of you. So definitely welcome everybody to the conversation. And yeah, go ahead, Eric.
Okay, well, I certainly endorse everything that Catherine said. You know, for me, when we talk about war, I use the very particular term of art that is a legal term. You know, we kind of bantered that about with respect to the question on Hong Kong and China. You know, those things, Catherine and I agree, never rose to the level of armed conflict. But I don't think that should diminish from what Ahmed is saying. I mean, his point is that these things that are going on are very serious manifestations of states getting involved and non-state actors getting involved. So I don't mean to at all to diminish what he's saying, and certainly not the importance of what he's saying. But from my perspective, I prefer to use that term war or armed conflict in a legal sense, because that tells me what legal paradigm I am going to apply. And so that, for me, I embrace the distinction that Catherine used from a legal perspective.
Can I say something?
Go ahead.
Yeah, thank you both, Catherine, Eric, for your comments. I completely agree with you regarding the legal aspects. Again, this is how I started. I'm not a legal expert. I'm just like tackling it from a communication aspect. But I just want to pick on one word, which is you said the objective or the goal is damage destruction. Yeah, I remember that word, Eric. You said cyber wars are supposed to lead to some kind of damage destruction. In my mind, damage destruction could be also manifested in different ways. Like, for instance, psychological, physiological, social, political. And I find this to be seen evident in almost all the, let's say, cyber operations that I have referred to. Many people were psychologically impacted. Jamal Khashoggi himself, if you read about what he said before his death, he said how depressed he was, how negatively moved he was because of the impact of the trolls on him. So, you know, there is also a Saudi feminist activist in Australia. She was one of the advocates for women driving. She actually quit Twitter. She said, Twitter is so toxic, I cannot even stay on the platform anymore. So talking about the impact of such operations, I find this to be very evident. Thank you.
Thank you. Okay, another question connected somewhat. Do you believe cyber warriors and cyber nation states that engage in cyber war are strategizing to indoctrinate citizens to fight from the local and regional level by using bots and social media to spread disinformation, propaganda, and DDoS attacks and hashtags. Eric?
All right, so I think this is a good way again to tie Ahmed's stuff together with what Catherine and I are talking about, and Paul as well. You know, the international law as it's currently configured seems to incentivize states to use non-state actors because under the rules of state responsibility, it is very hard to connect a non-state actor and to apply their actions to a state. This is under Article 4 and Article 8, and we can talk about this in greater detail if the listeners are interested. But what that does is that incentivizes states, because they can then say, well, it wasn't us who did this, it was someone else. That incentivizes states to use non-state actors. Now, this is much more prevalent under the UN Charter regime that Catherine started her discussion about than it is once you're in armed conflict. But the things that Dr. Ahmed was talking about, when they happen in armed conflict, the same kinds of concerns might arise. How would you, how would you attribute the actions of these non-state actors even in the course of armed conflict? So it's a great question. It's a difficult question, and I think that the current international law regime needs to adjust slightly so that we're not incentivizing states to use non-state actors to accomplish these things.
Yeah, Paul.
Yeah, if I might on that, I mean, this question, the challenge of attribution has been a constant one. For a long time, it was seen as completely impossible. I think increasingly now, through more sophisticated forensics, et cetera, there's a higher degree of certainty about attributing, and you begin to see now states more willing to publicly accuse another state actor for a malicious activity. I think what we're lacking, though, is some multilateral tribunal for accountability and to, in a sense, adjudicate who is guilty or culpable in a given action. And here in some of those UN discussions that I referred to, you're seeing the first suggestions being made about a mechanism, an impartial mechanism, maybe drawing a lot from private sector resources and expertise to make attributions. I mean, right now it's all in the hands of an individual state deciding to call out another, and of course they are biased inherently in their actions. So the notion is if there could be a more impartial, objective entity that could be surveilling the cyber activity landscape, and if it sees significant malevolent activity, in a sense, be prepared to identify. And then I guess the next step, which we're still lacking, is some sort of intergovernmental mechanism or forum where states would be held to account if there's credible evidence that they have been engaged in internationally wrongful acts, I think is the technical term.
Thank you. Yeah, Ejiamaka.
Yeah, I just wanted to add, just because of my perspective as a student, there's a lot of philosophy that I have to go through in like developing my research. But like, I think that talking about like using non-state actors in this way for students who might be interested in this as like a research area, I think you also have to look at kind of like going back to Foucault and the power of the message, and kind of like think about how a narrative is being kind of like drawn out here. With using non-state actors, it definitely has an influence on the citizens. It definitely has a target audience, and it's definitely having the effect that it was intended to have. So I think that it's kind of like almost like an iteration of that's the power in the message that is being shared for someone who's interested in the theoretical underpinnings of cyber warfare in this way.
Thank you. Moving on to the next question. To what extent do you see cyber warfare as an increasingly conventional form of war versus a somewhat guerrilla or irregular form of war, given who can undertake cyber attacks and what it can target? Paul?
Yeah, I can at least maybe going on that. Clearly one of the points I think Eric flagged this in his presentation as well is that the threshold for getting engaged in offensive cyber operations is much lower than it has traditionally been the case with other forms of military activity. Compared to that, $2 billion aircraft carrier, you could pay $200 or maybe $2,000 for some rather sophisticated laptop and the kind of malware that you could now purchase on the dark web, and you too are able to engage in offensive cyber action. So that clearly is one of the dilemmas that's posed, and it's also encourages this irregular guerrilla type activity. And again, as has already been noted, though that sometimes states can hide behind non-state actors as plausible deniability and have them, in a sense, do their dirty work for them. So it is very much a problem, and that's why I think it's important to develop norms. And then we have to recognize, however important international humanitarian law is, it's only one element of international law writ large. And even beyond legally agreed actions, there's a wide area of norms of behavior, sort of political arrangements. In some cases, those might be more readily agreeable among actors. But it's important, in a sense, to articulate what norms of responsible behavior are. And that helps create, I think, a climate that at least has the potential to then stigmatize those who deliberately violate those norms. Thank you.
Thank you. Anyone else who would like to add to that at all? Okay, next question. What can be done to protect humanitarian workers in zones of complex or fragmented conflict? What about when the actors are criminal actors who are sometimes participants in the armed conflict?
So I can take a first stab at that, but open to everybody else to weigh in. So for the Red Cross and Red Crescent movement, some of the work that we do in order to protect humanitarian workers is really education. So reaching out to everybody who's involved in the fighting, that can include people who are alleged to be criminals, as was the language that's used in the question, in order to explain who we are and what we do. The fact that the assistance, so long as it is impartial, so long as it is humanitarian in nature, making sure that it is getting to those individuals who need it and who are recognized as needing it under IHL. So that really can be a matter of sitting down with people, reaching out, asking for their time, asking sit down and explain who we are, what we do, and why we're doing it. Seeing that can be a benefit to all of the parties, again, even groups who can be deemed to be criminal actors, and explaining and showing the benefit. And as Paul had mentioned in his last question, creating the norm and the practice, that it is actually in everybody's best interest to allow for that humanitarian assistance and the protection of humanitarian workers to get through. And so in addition, it is recognized as a crime under international criminal law to target those who are providing humanitarian assistance. It is a crime to attack individuals who are wearing the protected symbols. So that recognizing it as a crime also is meant to act as a deterrent for individuals who are thinking about targeting humanitarian workers, and making sure that they realize that if they do, there are consequences.
Thank you. Okay, next up is, what do you guys think the future holds? Paul, go ahead. We'll start with you.
I'll just start. I used to say as a diplomat, you had to be a professional optimist. And even though there are many dark clouds out there, I continue to be impressed with the capacity, the human ingenuity in the face of significant threats to promote what at times is really remarkable cooperation, particularly when you see the diversity in terms of power and capabilities within the international community. So I remain hopeful, and though the process at times seems slow, maybe even glacial, I think there has been, as in the past, at times when a majority of states begin to think that certain things that might have seemed attractive at the time, in the end, are not worth or pose more liabilities than advantages over the longer term. There was a time when, chemical weapons were just a routine part of the arsenals of states around the world. And then eventually, over time, and with the repugnance that the publics had with the use of poison gas during the First World War as an impetus, I mean, you finally, decades later, had a comprehensive prohibition against chemical weapons. And, yeah, there are a few outsiders still, but very much that has become a real norm. So maybe it is a little idealistic to think eventually we could have a system that preserved cyberspace for essentially peaceful purposes. But I think it's an objective worth at least trying to advance towards.
Thank you. Ahmed, did you want to add something?
Yes, thank you, Paul. I'm actually going to say something exactly opposite of what Paul mentioned. I'm a pessimist here. I think cyber wars will only get worse. With every new device, there will be someone coming to hack it. Governments are actively working to hack as many devices as possible, starting with the NSA, ending up with China. The sophistication of the attacks will increase. We should be more concerned about civilians who have no protection, no defenses. That's my concern amidst this kind of ongoing cyber wars happening.
Thank you. Okay, for the sake of time, sorry, Eric, we need to wrap things up. I want to say a huge thank you to all of our speakers. Thank you so much for taking the time to be with us today, and thank you for spending time having this chat. I know it's been very insightful. I'm going to pass things back to Karen to wrap up.
Thank you so much, Samantha, and thanks to all of you that asked your questions. I know that we weren't able to answer all of them, but if you are still interested in accessing resources or you have additional follow-up questions, please email me and I'll do my best to link you with the speakers and the resources that have been discussed today. I want to thank Samantha for moderating today's conference. I want to give a big thank you to all the presenters for your insightful talks and your expertise on this very important topic. And I want to thank the steering committee volunteers and my colleague Irina for the work behind the scenes. So thanks, Irina. Thanks, Samantha, Yuna, Ashley, Jane, and Shakiba. Now, I would like to thank everyone that signed in today under Zoom or through YouTube. We're very lucky to have your participation. For those of you who are new to the Canadian Red Cross, one of the areas we work on is the dissemination of international humanitarian law. And we do this by organizing events across the country, including online events, as we did today, to educate Canadians and others on international humanitarian law and related issues. So to find out more, visit our website. I've just put the link into the chat now. I also wanted to encourage everyone to share your feedback on today's conference. So please do take a moment to complete an evaluation of this conference by going to the website SLIDO. That is sli.do, and enter the event code IHLVAN. There are just a few questions that will only take you a really quick moment to answer, and we really rely on your feedback to improve the quality of our events and to ensure we are bringing you relevant and interesting information about international humanitarian law and humanitarian issues. So again, a big thank you to everyone on the call or on the conference online today, and we'll see you next time. Thank you.
Thank you.
Thank you so much.
Thank you.